Good morning. I am here with Tim Chapman. He is the chair of the European Forum for Restorative Justice. He's based in Belfast, and I'm going to ask him a few questions. Hello, Tim.
Hi, Annemieke. Nice to see you.
Yeah. I would like to explore a little bit the work in the field of restorative justice for young people, for children and adolescents. And you've been working on that topic next to many other topics in relation to restorative justice. But can you explain how you got involved with this specific topic of young people?
Yeah. Before I really got into restorative justice, I was a probation officer in Northern Ireland, in Belfast, for about 20 years. And the part of the work that I enjoyed most and found most challenging was working with young people in conflict with the law. I was fortunate to be involved in several very innovative projects at that time. And then I discovered restorative justice, and we started to implement in a very low-level way restorative meetings within probation, but it just wasn't the right time. It didn't catch on. And so I left probation and studied restorative justice. And then the law changed in 2002. Mm-hmm. And they were looking for an expert who could advise the government on how the law for restorative justice should be implemented and to train people. And because I knew a little more than other people, I was the expert, and I got a job as a lecturer at Ulster University. And we developed the model for restorative conferencing in Northern Ireland, and then trained, many hundreds of people.
Yeah, because I heard this model, the Northern Ireland model, the conferencing model, is really put at the heart of the criminal justice system for young people. I understood. How does that really work?
Well, it is. I think we were very lucky, and I'm not sure that the legislators fully realised, because in Northern Ireland, a judge or prosecutor must offer a young person the opportunity. Mm-hmm. So they don't have any discretion. They don't pick suitable cases. They have to say every single young person who admits responsibility for a criminal offence must be offered. And that's even if there is no identifiable victim. It could be a drug offence, motoring offence. Yeah. So, and also it means that even for somebody who persistently reoffends, they also get a conference. So it's a remarkable law. I'm not sure people had really thought it through, but it is established now. Tens of thousands of conferences have happened in the last, 17 years. We estimate about 1 in 20 of the population has been to a restorative conference now. It's accepted, it's institutionalized. Nobody thinks it's a strange thing anymore. So we were very lucky.
Impressive indeed. Compared to other systems in Europe. But are there also challenges still?
Yeah, I was a great supporter of this approach. Obviously, I'm totally biased because it's my country and I had an influence over it. But we had a PhD student, Olivia Barnes, did some research into it a few years ago, once it had really matured. And that made me realize that there are institutional pressures on restorative justice that can weaken its value base. The things that Olivia found were that that victims were being, to a certain extent, marginalized, that the process was becoming a bit of a sort of conveyor belt, that it became very routinized, scripted, and that reparation was almost already in place before the conference had happened. It was sort of pre-organized reparation for people. And a lot of the sort of spontaneity and the power of the parties within the conference was being taken away by the professionals, almost like Neil Christie.
Yeah, you see that more often. Okay.
Yeah. So that was a big eye opener to me and made me realize that something that I believed in can also have serious faults.
Yeah, and you and I are working on a book on restorative justice and children's rights, and there you also write about these risks and factors that are related to the field of children's rights and restorative justice. Can you explore a little bit more on those risks?
Yeah, having studied Olivia's research, I became interested in this and discovered that there's been a lot of research into these problems in Britain and in Europe and in mainland Europe. And the same things keep coming up, that the system likes restorative justice, but eventually tries to mold it to suit the system rather than to suit the people in the community. And so it's very difficult to balance the needs and rights of the offender with the needs and rights of the victim. And if there is a choice, the victim loses out. In times of austerity, and this was one of the reasons that there was less resources, that people take shortcuts because they're under pressure. And so they maybe don't spend as much time in preparing the party. So they, there was evidence of young people and victims coming into a restorative conference or a mediation without really understanding what it was about. I mean, literally, there were some young people who were in conflict with the law were surprised to see the victim at a meeting. They didn't realize that was going to happen. So, and also a very sort of low victim attendance and low victim participation in face-to-face meetings. These things I discovered were much more common than I thought. And it presents a real challenge to the restorative justice movement, that we need to maintain that space for people to come together and talk about their problems without being dominated by the system that they're in.
Yeah. So, how do you see the way forward?
I think we need to be a lot more clever at when we're setting up restorative justice, say within the criminal justice system, or it also applies within schools and other institutions, that we say you need to respect the restorative space. Yes, restorative justice will benefit the system, but it'll only benefit it if you respect restorative justice. And I think children's rights have a part to play, because I think children's rights can create the sort of boundaries of that space. I'm thinking particularly, for instance, the rights about discrimination, to ensure, because I discovered evidence of discrimination within restorative justice. In areas like Australia, New Zealand, who are great pioneers of restorative justice, the Maori people and the Aboriginal people were not getting the same deal as white people, even though the white people had borrowed their traditions to develop restorative justice. So discrimination, best interests of the child, very important. And that refers obviously both to the young person in conflict with law and the victim, the young victim, that we need in preparation to look at the best interests of the child. I personally believe that 9 times out of 10, restorative justice does serve the best interests of the child. But of course, there are exceptions. And then, of course, the voice, in protecting the voice of the child within the process. I think those rights give a very solid foundation for restorative justice within a youth justice system.
Yeah, and to use it in a proper and well-prepared way, and then it has the prosperity that we want to see in it, and that gives really the voice to children themselves and the other person involved. Yes.
That's the important thing.
Thank you very much, Tim. I'm going to share this with our restorative justice followers in the Netherlands, and we would like to see you again. And thank you very much. And have a good restorative justice week yourself.
Yeah, well, pass on my regards to my friends in the Netherlands and my respect for the amazing work that you're doing now in the Netherlands. It's an example to us all.
Thank you.
Thank you.